more than the average Superior Court judge, and I think most of them would publicly say I wrote more than I ever should have.
Just a ballpark figure, what is your overturn rate on your appeals?
Very low. I never keep track. When, I do note that as a judge, we make thousands of decisions, not only those which we write, but every trial we're making evidentiary decisions. We're ruling on discovery motions. We make decisions every day, and a whole lot of them may not seem terribly consequential, and some of them may come back at us. I've been reversed more than I would like. But I don't think I really have not kept track. If I were to, I probably should not guess, but because a lot of these decisions are common, they're 128s and they're only a page long to affirm. I would say in the ballpark of about 5% in terms of written decisions, but that's a very rough ballpark, and somebody could go back and do the research and find that I'm wrong. But I do get reversed. I am in error at times, and then told so by our appeals court and our SJC, but fortunately not that often. And I also think that most of the reversals that I've had have not been really for as much for errors of law as for areas of law where there is uncertainty and the law has been developed. There really haven't been very many in which they said there was this case and you just missed it.
I'm not a lawyer, so I have a question that I had noticed recently, that you had an injunction issued against the mortgage foreclosures, and this was upheld. What do you say to the criticism that people should be held responsible for their mortgages and what they sign?
And people should be held responsible. And the Fremont decision, which you're making reference to, and then later the Regional Block decision, expressly says that. What the decision in a nutshell says is that both sides bear responsibility, that there is in the common law this concept of predatory lending, basically providing a loan which the lender reasonably knows the borrower could never pay and would be due to foreclosure. And that is predatory lending for a lender to do that. Those decisions have also said that, I said it quite clearly to the borrower, don't think that means the loan is void. It doesn't mean that you don't have an obligation to repay. What it pragmatically means is that that is a loan which reasonably should be modified so that it can be made one that a borrower reasonably would be able to repay. So the issue really is modification. I made it very clear that the mere fact that a lender is engaged in predatory lending does not mean that the borrower is off the hook, but pragmatically it means that that is a loan which the court would say should be in some fashion modified.
This is something very personally important to me, and I have to add. Talking about independence on a board, and particularly the highest court in Massachusetts, is so important. Is there any value to you in a dissenting opinion of this SJC? And if so, what is the value of dissent?
I think there's great value in dissent. I think you and I even spoke about the late Justice Martha Sussman, who was a good friend of mine, who in her day probably did more than her share of dissents. I think her dissents, everything she did was very, very carefully reasoned, and I do think that the presence of dissent does keep everybody on their toes and fair and honest. So you remember Justice Brandeis from the U.S. Supreme Court. I think he was known as the great dissenter in his days, and a fair number of those dissents are now, which we forget that they were dissents, that they appear to be part of what we understand to be the prevailing law. But I do think there is an important role for someone to dissent when the issue properly is what is believed to be an important dissenting point.
Now, Judge Bosman, I have the pleasure, like you, she was in my district, and as you know, I presided over her hearing, and we miss her, and she's just wonderful. She's a wonderful person. This is the most important question to me. Can the public count on you to stand up to the majority, to be the minority when you believe the majority is wrong?
Well, I mentioned in my statement that even before I was 30, I was referred to as a hair shirt. The FBI, as you may expect, is not the easiest place for a kid pretty much out of law school to be speaking his mind and saying certain things don't make sense, so we should rethink certain things. I did it then when I was 28, 29, and I don't think I've assaulted that much since. So I do believe that the SJC is a collegial body and should be, but I have no reservation about my ability to stand on my own when I think differently from my fellow justices.
Now, what judge would you model yourself after? Had any judge?
Judge Nickerson is the judge I don't know I would, but I do. I think of him all the time. In fact, actually, he passed away in 2001, but I was thinking of him so much that I actually Googled him trying to find his daughter, who I know had married a Venetian gondolier. And I had actually had seen them when we were in Venice, and I was trying to find them, but of course the name was too common. What I did discover during my Google search is that he is a direct descendant of John and Abigail Adams, which he never told us when I was clerking for him. So I did not realize that he was a direct descendant of that family. So that's as close as I get to the author of our Constitution as having clerked for Judge Nickerson for that year in 1980. But he's the one who I think of most on.
Now, we spoke about this, about sending letters to the JNC, and you said that you didn't and you weren't invited to do so. And I just wanted to put that on the record.
I'm sorry, to the JNC, the letters were sent. I didn't encourage all my friends to write you, but it was routinely done that you would write letters to the JNC.
You asked people to write to you?
At the end of the first process, they say you can have 10 as part of the routine process, and so to them, they got their 10. I didn't, when it came to you, seek to inundate you with letters. I suspect you may have gotten. I really did not put together any particular effort to have.
Well, I had asked the JNC to have any letters of our non-meeting this past year. The winner. I don't want to, interfere with the confidentiality of anyone that did not get the position, and I was refused, and that's why it's important for me to know, because I think that should be disclosed to the council and to the public, and because any time that I know other council and myself, any time I get a call to recommend someone that knows the nominee, I welcome that, and I publicly stated on the record at the meeting. And in fact, Judge Backrack was the first person to call, and three people in particular that I respect called me: Judge Backrack and Judge Neal and Judge Green, and that's a public process to let people know. But to me, to just have the JNC keep those letters of endorsement and not make it public doesn't seem appropriate when that judge that nominated and appointed is going into a court. Who those people are. I think the public has the right to know. So I appreciate that. But I have to mention, you're going to be in the Governor's Council